All right, we're going to go ahead and move on since we're a couple minutes, but we're going to give our next speaker, Peggy Hall, 90 minutes to talk about a couple of talks here today. The first one is, first of all, Peggy Hall is OSU Agricultural and Resource Law Program, so professor here at Ohio State and with Extension. And she's first going to be talking about legal developments in the carbon and conservation markets. And then she'll transition into legal issues with solar and wind energy on farmland. So, Peggy, it's all yours. Thank you.
Thank you, Aaron, and hi, everybody. I see some people had enough carbon and left us. But now we're getting into the good stuff, and that is the legal issues that come with some of these transactions that we're seeing out there already in place. So I want to cover a couple of different things. This is a pretty controversial issue, as many of you have already illustrated. I don't think that's what I want to do. There we go. Okay. So you can learn more about what I do if you're not familiar with the Agricultural and Resource Law Program at OSU. I'm part of the Farm Office team. We have a website, a lot of information on that website. We, Robert Moore and I, the two attorneys in the program, and we write agricultural law blog posts regularly for the Ohio Ag Law blog. We have a lot of events that are always posted there. So please do check that out if you're not familiar with us, because it's very likely that we have either an agricultural law or a farm management resource that will be helpful to you. There's a couple of items there, the Ag Law blog and the Ag Law library that you see circled on the website. And then coming up this Friday, every month, we take a little break in the summer, but every month we do something called Farm Office Live, where our whole team will cover current issues in farm management and agricultural law. And that's coming up this Friday. That's a free webinar that we offer too. So I've spoken several times on that program about carbon contracts and carbon markets and some of the issues that I see coming with those. And I have to tell you, I haven't been a huge fan of the carbon credit from the legal perspective as an attorney. And usually that's one of the last things we think about. Typically, we immediately think about, well, how much can I make from this, right? And that's understandable. We're farmers and we are here to make money. But that's something that I hear a lot. Well, how much, and Mike asked that, how much are these credits going for? How much is it going to add to my bottom line? So the economic consideration, first and foremost, then we have that agronomic issue that we've already been talking about. How exactly do we create and measure these things? But last, and maybe sometimes never, do we talk about the legal issues, but I will touch on what to look for in a carbon contract. But I also want to raise some other legal issues, because I think there are some very serious issues that we should address if we really want this market to be sustainable. So I want to cover those. First, the legal nature of this thing that we're creating when we create a carbon credit. I think that's a very important question. Mike already touched on some of the federal policy developments, and I want to touch on a few more that relate to these legal issues that I'll be addressing. And then there is the emerging litigation risk. It's something that many of us in my field raised a flag of right away that, oh no, what are we setting up here? And it is starting to emerge. We are seeing litigation, mostly coming from Europe, which is ahead of us, but I'll give you a little bit of insight into what's going on there. So when we think about that carbon credit that Mike's been talking about, it's very different than the commodities that we're used to producing in agriculture, right? And it's that creates a lot of the legal issues that worry me. We don't know what it is. We don't know the legal nature of that instrument is that that transaction. What is it? Is it real property? Is that what a carbon credit is? Or is it personal property? Just that question we could kind of debate for a while, right? Are you creating an interest in real property, or are you creating something that you personally own as a piece of paper? What is it that you're creating? We have not resolved that at all in this country. But we can find that there are some cases that I've seen, and I apologize, I thought the screen would be much bigger. I hope you can see the print on there. But you can see a few cases, some guidance from the IRS. That always makes everybody nervous when the IRS gives some guidance on something. But the first one out of California, there was a federal court trying to examine that question. What is this thing? What is a carbon credit? And that court said that, well, it's associated with property. It's a property interest. It's a property right. But down in another case, dealing with the California cap and trade program, you got an opposite result saying, well, no, it's not a property right. It's a personal interest. And it's like what we call commercial paper. It's a transaction on paper that follows the person. Why does that matter? Well, think about if you own the land on which a carbon credit is being generated, or if you're the tenant operator on that land generating the carbon credit, who actually has the legal right to that credit over time? Is it the person who created it, or does it flow with the property? We have not resolved that issue. And then we have to think, of course, about tax and the Internal Revenue Service. And they have issued a few statements. They're getting rather old now, in 2011 and 2017, saying that a carbon credit is the sale of an interest in real property, and that carbon credit restrictions are the sale of an intangible asset. And so we have to think down the road about some of these tax ramifications, especially as we start transferring estates, and at what point and where and who values that asset. How does that play into that overall estate? So I feel like I'm all doom and gloom, but it is my job to raise some of the issues that I worry about for the future. We may not be dealing with these yet, but I think that they will continue to rear their heads. The second issue is we actually have no infrastructure at all to track these things that we're creating. These are private transactions that live in a fictional contract world, in most cases where you can't even share that contract with anyone or tell anyone what is in that contract. So transparency is a very serious concern with these issues. So, and this relates to the last question, what is the legal instrument that we've created? How can we document that? How can we build a market around it when it's a secret agreement with no transparency? Should we, I know there are some companies actually that are saying, well, when you sign this, we also want you to sign an easement. An easement is a legally recorded property interest. So now we at least know that it exists, but imagine this world where we're signing these contracts, creating these tradable things, and nobody really knows where they exist and how we can confirm whether they exist. In our typical property law scheme, we have ways to track things. In our contract law, and especially with commercial contract law scheme, we have ways to track things so that we can go to those instruments, see what's going on, see what has been traded, see what somebody else may have already purchased. We don't have that kind of a scheme here. And so the concern that you'll see that relate to here in a moment is the potential for fraud. There are no legal execution requirements, no formalities, nothing that would record an instrument. And typically when we are dealing with property interests, and Ohio, like many other states, say we need that in writing. And if you want to enter into a farm lease, you better have that in writing if you want it to be legally enforceable. The way to protect yourself is go down and record that. Now everybody knows that that legal interest exists. We don't have anything like that going on with these carbon contracts. So what is it, again, is a question that I keep asking. You know, how do we create it? How do we document it? how do we know if it's been retired? Or if, Mike mentioned the possibility that something could happen and that credit would go away, and yet we have no way of tracking that either. So a lot of concerns that I have for this lack of legal infrastructure for this interest that may or may not be a property interest. Maybe it's a personal interest and we don't have to have this in place. I would argue that we should. Another concern is there are high compliance risk characteristics with this type of instrument. And I point out too here that Mike's already touched on a little bit, but because these provisions within these agreements do often bring up additionality and permanence, saying, and many of you have already touched on that, saying that you're only going to be paid for new carbon that you're sequestering. It has to be the result of a new practice. That in itself, of course, raises the uncertainties that many of you have already pointed to. And then that issue of permanence, that it has to stay in place in perpetuity. And what if it doesn't? And what if it's someone down the road who didn't even sign the carbon credit agreement does something to destroy that sequestration of that carbon? We've got a lot of opportunity, I guess, for compliance risk within those scenarios. And will there be an attempt? We don't know that. By whoever signed the contract previously, that aggregator of those credits, will they come back and try to enforce some of those provisions at some point in the future? And will they even have what we call privity of contract with the person who now owns the land or is doing the practice that interfered with that carbon credit? So see how I could just write a great big law exam question on this, right? Yeah, so I think these questions and comments that you have, though, kind of highlight some of the concerns we have, right? That maybe we've put the cart ahead of the horse here. We need a better system in place to ensure that we can sustain this market. I think a lot of people would agree with that. We don't know what that system should look like, though. I think that's where we run into problems, and so we've gone ahead without it. Another issue, there's a recent study here that I show you up in the corner there, that it is that fear of liability for not complying with the contract that is holding a lot of farmers back. Mike already talked about the first one. We haven't gotten to the number yet. And I just saw recent in the Ag Barometer that Purdue does. A lot of farmers in the back of their minds, they're thinking they need at least $60 per ton to do this. And we're not there yet, but there's also this fear that's kind of having a chilling effect on entering into these agreements. The fear of, well, what if something goes wrong and I can't comply with this contract? And I think additionality and permanence could be two factors that are leading that fear. So let's go and look a little bit at some more federal policy developments and what's happening there that could affect this market. Mike already mentioned the USDA partnerships for climate smart commodities, that's now up to $4.5 billion for these practices that hopefully will bring a little more certainty to, what are we generating? How are we generating it? How do we quantify it? And there's, as Mike said already, more money coming through the Farm Bill. There's the Carbon Credit Market Assistance Program that now is being handed to USDA to implement. This was previously, you may have heard of it as the Growing Climate Solutions Act. It bounced around for several years. It passed the Senate. It couldn't pass the House. It kind of hung out for a while. And then finally, at the end of last year, right at the very end of last year, Congress stuck it in the appropriations bill. And so here we have it. They changed the name. Now it's called the Carbon Credit Market Assistance Program. And it has been handed off to USDA, and they are in the process now of determining how they're going to implement that program. So the goal is to facilitate greater participation. As we know, there's only something like 3 to 6% of farmers who have decided to enter into these agreements, to keep an eye on making sure that revenues are being distributed fairly, and to increase information for all of us in the ag community about these markets. So those are the goals of the legislation. They're going to try to put an advisory council together. They have not yet appointed that, but many farmers and forest landowners will be on that advisory council. What is disappointing about the law that did finally pass, they changed some provisions, and you know, we keep having these issues of registries and protocols. There are provisions in there, but instead of creating some kind of a certification program, which is what many people wanted, they decided to go to just publishing lists of protocols that are widely accepted, that help ensure the consistency of credits as they're generated and how we're quantifying those. Also, some protocols that would increase the transparency of the markets. But these are just lists that USDA would publish. There would not be any kind of certification or oversight of those protocols and the supporting documents. So it's going to, I think, maybe be a little bit of a free-for-all as people try to get their protocols and their documents onto this USDA list. And as I said, many people instead wanted some kind of a oversight and certification procedure for that information that we felt sure could be shared on these market transactions. And then number 4 there is that third-party vendor situation. Again, wanted certification here of those third-party vendors who farmers could reliably go to have that assistance with quantifying these carbon credits and understanding which practices would generate the amount of credits for a particular soil type and geographic area. So there, again, was an attempt to try to have a third-party certification system so that you would know as a farmer that this person you're relying upon has been vetted by the USDA. That's not going to be the process. It'll simply be a registry of those third-party vendors. So they can offer themselves up to be on the registry. There is a little bit of a duty upon USDA to check them out, but no certification process. And then this new law would require USDA to continue to monitor and prepare assessments of what's happening in the carbon market. So it was a long time coming, but we do have something in place now that will lead to a little bit of governmental oversight of the market itself. So then we have some of our government entities very concerned about this issue of fraud, and we've touched on it a little bit, but the Commodity Futures Trading Commission just this week made a statement about, you know, the susceptibility of this market to fraud and manipulation. And much of that ties back to some of the legal points that I've raised already. You know, the lack of transparency, the lack of a clear identification of what kind of legal instrument we're actually creating when we create these documents, the lack of a registry or property interests that can be recorded and viewed and tracked. So the CFTC is concerned about many of those things, and they actually compared it to the crypto exchange market. You mentioned crypto. Mike, you know, there was a big failing of the FTX market, and also some of the issues that we've seen with the renewable fuel standards market, and worried about price discovery. And again, many of these contracts are confidential, and we don't know what the trading prices are going, not within the contract that we would sign as landowners, but also those transactions that are being sold to others who are then claiming those offsets. So a lot of concerns there about price discovery and whether the market can continue to grow without more transparency. And then the SEC has even weighed in on being concerned about false and misleading statements, and that kind of ties into what I want to talk about next. The misleading disclosures that might come not by the aggregators like on the indigo end, but on the other end, those who are purchasing, that there could be some issues there that get us into some securities problems. So many are questioning, to deal with this potential of fraud, are these voluntary efforts enough? We have some of the registries already mentioned. We have this Integrity Council for the Voluntary Carbon Market, which is a global effort to bring more transparency to this market. Will that be enough? When you talk to the regulators, of course, they say no. They think that we need to have a little bit more transparency in place. So that's something that we need to keep an eye on coming from those other sources in the government beyond USDA and the ones that we deal with from the agricultural perspective. And then finally, I want to tell you a little bit about litigation risk, and where a lot of the risk is coming is not right now from litigation for the contracts that you might enter into. It's actually a lot of litigation going against those who purchase the offsets. Those that greenwashing, have you heard that term before? Saying that, oh, these companies are just greenwashing. They're saying, well, you saw Mike's example of, which airline was that you put up, Mike? Or you didn't say. Of you can purchase fund an offset and it will, plant so many trees somewhere and generate so many credits somewhere. Those kinds of marketing efforts by those who claim to be paying for carbon credits are leading to many lawsuits. And there right now, beyond the US, 25 lawsuits going on against companies for misleading advertising, saying that they are purchasing carbon offsets and not necessarily what happens. There's cases, sorry that's so small again, against Shell, KLM Airline, Total Energies, some of the bigger companies that are being faced with these lawsuits for misleading advertising all around this issue of carbon offsets. Some of the litigators, and I will say there are some fairly organized and well-funded groups that are coming after this from the environmental community, saying this is greenwashing, this is just a sham market, there really isn't carbon sequestration occurring. Some of these companies are using it just to make themselves look good. So these are the kinds of issues that they're raising, and so they're using that to come after them for the false advertising. So the offset is a marketing fiction. That's one that you'll see in some of those lawsuits, that many of the companies aren't actually taking steps to verify that they have created a carbon or purchased a real carbon credit, that there's doing so, that it's saying they're going to go out and plant 1 million trees is now increasing competition for land. There's even a bit of a social argument here that it's actually going to deprive the poorer parts of the world of their land base, because they're suddenly going to be just planting trees everywhere for these so-called credits. I don't know how, I'm not saying that any of these are legitimate arguments, but these are the arguments that they're using and bringing into many of these lawsuits. And then the last one, many of these groups are saying we are fine with natural carbon projects. We just don't want the carbon credit transaction because we don't believe it's a valid market. So all of that going on coming from the environmental community that would be opposed to these kinds of credits. Is that enough to have a chilling effect on the market? I don't know. We haven't seen many of these cases in Ohio or in the US. They've all been over in Europe because Europe is ahead of us on this. So will they come? They may come. Something we have to watch. And then there are some countries that are already picking up existing laws or passing new laws specifically to deal with this issue of misleading consumers, consumer fraud, misleading advertising. Those laws, you can see that Germany had passed a new law that allows for greater enforcement against those who are claiming to be carbon neutral without being able to back it up and prove that they are truly offsetting their emissions, and they're offsetting them with these practices or credits over here specifically. So we're getting a bit specific in some of these concerns. France has a new law that requires clarification if you're going to use this marketing that you are reducing your carbon or that your footprint is minimized, then you better be able to show us how you're doing that. And so there are many other existing laws that could be picked up in the United States and used in this way that go to consumer fraud. We've not seen it yet, so a question mark there on whether that will happen. So as far as the contracts themselves and whether we've seen any litigation, I told you, a lot of farmers report a fear of non-compliance and maybe being taken to court, having that contract enforced. I've dug around a little bit. I haven't found much going on here, but here is this case from Brazil, a big case in Brazil, where there was an exchange between the two companies, payment made by that offset provider who turns around and sells the offsets to the companies. The carbon credit aggregator did not deliver the carbon credits, though, as promised in that agreement. They still haven't been delivered, to my knowledge, and we're talking about a couple of $1 million beyond that in this case, where the payment has been made, but the credits are kind of hanging in limbo. Where are the credits? So they're involved in litigation down in Brazil. And my Spanish will not allow me to tell you the name of that case. I don't know, but that's what it is. Oh, is it Portuguese? Oh, thank you. Yeah, is it Portuguese? Okay, so I want to finish up by thinking about, so what do we do now? I've kind of laid the stage that there's a lot of uncertainty and risk in this market right now, but what do we do, especially if we do want to engage in these practices that reduce carbon? Well, I have a few thoughts on carbon contract considerations. I have been able to review just a few of these, and a lot of what I share and what I know is coming through hearsay as to other attorneys or those in the farm community who have been privy to some of the contracts. So a few considerations to share with you. First is really making sure you understand what the required practices are. There tends to be, they tend to be broad. And I think that's partly intentional to give you the discretion to decide what practices work into your operation. But that can be a double-edged sword if you don't fully know what is expected of you. And you need to understand how those practices could relate to those issues that we've already discussed of additionality and permanence. So it takes a little bit of a cyclical thinking process to understand what's expected and how might what I do actually create some problems with some of the other provisions in the contract. So paying close attention to that required practices type language. Also looking at the term or the length of that contract. There have been many contracts that say that an extension is automatic upon the request of the person on the other side, but not upon the landowner. So the company can extend the contract, but the landowner cannot. So be careful about that. This is where you might find the permanent type language in kind of looking at the term and the length of the contract. And so you have to tie those together. If it's a 5-year contract, yet you're somehow being held responsible for maintaining permanence of that carbon credit. How is that going to happen? And what is your risk exposure there? Also, if there is an early termination provision, oftentimes there are penalties tied to that. So being willing to weigh that risk. If you get into this and you don't like it and you do terminate early, what's it going to cost you? Because it's most likely going to cost you something. And that kind of ties to, again, Mark, to your, what are the recoupment, what are the penalties for something going awry? Well, some of them will allow you to get out, but you're going to have to pay to get out. Payment terms, are you paying, Mike touched a little bit on this, are you paying for the outcome, the generation of X tons, or are you paying just for doing the practice? Because we see them structured differently. So a little more certainty with the practice, as Mike said, than with the outcome. But some of them are structured that you're going to be paid on how much you reduce. So the tonnage of the carbon that you sequester. If that's an issue, then we really need to pay close attention to how we're confirming that that has indeed been generated, that we know how it's being verified. And that's the next up there in number 4. What approach are we going to use to verify what you've generated? Some models exist, as Mike mentioned. Sometimes we might have some actual measurement provisions and some testing provisions, and then we want to know who will pay for those, the measuring and testing and confirmation of the credits generated. Or are we just going to rely on a modeling approach? Or sometimes there's a blending, kind of a hybrid of all of those. And then stacking is something that we often see as a concern too, and that's number 5, restrictions on other opportunities. It's called stacking. Can you stack this program in with another program that you might be paid for? Or are they saying you can only be paid by us if we're your only program? And what exactly is a program? Do they mean you can't do another carbon credit program? Or do they mean you can't do a federal program like CRP? We need a lot of clarity there so that we don't violate those stacking provisions that say you can't double dip. That's another way of looking at it. You can't be paid by us to generate this carbon credit and then be paid by somebody else to do it as well. So watch those provisions. And then Mike mentioned data sharing. There's a reason that they want that data, and that is to help them confirm what you've been doing. If you're not comfortable with that, I think that's something that is in every contract I've ever seen, that you will share your data as part of this agreement. So if you're not comfortable with that, you might not want to go with this kind of an agreement. And then finally, there are many of those general legal terms that we put in just about any contract that you'll see in these types of contracts, like assignment provisions, how disputes would be resolved. Some of them have class action waivers, which makes me a little bit nervous, because when we are in an uncertain market like this, one legal strategy that we might utilize is everybody come together in a class action lawsuit to deal with this issue. And some of these say, no, you're not going to be able to do that. So be aware of that as well. How about some questions on some of those provisions? Anybody have any questions? There's a couple of good resources if you are considering this that I can refer you to if you want to email me. I have my email coming, but where those who've been tracking this issue have been able to gather agreements and compare agreements and highlight some of the terms, and I think that can be useful if you can find the party that you might be dealing with in that list. And I know many of the companies that are most widely used are in that list. Okay, so, and a final thought here. as you consider a carbon agreement, you have to really be looking at your own land and understanding, of course, and that goes to many of those agronomic questions. What is your land actually capable of? Can you meet the expectations in this agreement? Those two have to be thought about in tandem with one another. And then finally, I would love to see Ohio legislatively care about this issue and try to create some kind of mechanism for documenting these interests, assuming we go with the conclusion that they're property interests. If we go with a personal interest, then we're looking at something like our UCC filings that we see on equipment, loans and liens, that kind of an approach. But I think it's fair to say that it's something that kind of lays with the land, and so the property argument seems to be a stronger argument. So how can we document that property interest, know that it's there, so that we don't have some of these issues with conflicting with that interest in the future, and so that we can verify that it exists. There could be some, real issues with that, and I know that in some other states and some other places, they're looking at some kind of cloud-based recording and GIS interests because of the nature, again, of what we're creating. So a little bit of a challenge there, but I do think we need to push this issue of we need to verify what we're creating and create some kind of record of it in order to make this market sustainable. So with that, I'll open up to questions or comments. There's my contact information if you do want to email me, or I can send you additional information. If you are considering agreements, a lot of my colleagues have written many things, so we can just inundate you with legal information if you're considering an agreement. Okay, questions?